In response to my first three questions, I'd like a simple yes or no answer from both of you. We'll start with Mr. Simmons and then go to Mr. Delrahim for each of these three questions. Mr. Simmons, do you believe that your agency could benefit from more resources to enforce the antitrust laws?
Yes.
Mr. Delrahim?
Yes.
Would it be a waste of resources, those that you have within your agency, for your agency to be investigating the same conduct in the same company at the same time as something that's already being investigated by the Department of Justice?
Yes.
Mr. Delrahim, likewise with
Yes.
respect to the FTC. Mr. Simmons, are you aware of any instance, any matter prior to 2019 in which your two agencies were investigating the same company for the same conduct at the same time?
No, Senator.
Mr. Delrahim?
I don't recall. No.
Okay, thank you. Let's move on to clearance. Back in June, news reports suggested that your agencies had divvied up review of the dominant tech firms. But in July, the Justice Department announced that it is conducting a broad review of the leading online platforms. It sounds to me, in context, like your two agencies are covering the same ground, at least in very significant part. In fact, the Wall Street Journal reported yesterday that the Justice Department may conduct its own antitrust monopolization-related investigation of Facebook, despite the fact that the FTC is already investigating Facebook under a monopolization theory. Chairman Simmons, are the FTC and the Department of Justice still operating under a clearance system to avoid duplicative efforts, or have things broken down on this front?
For the vast majority of matters, we continue to operate under the existing clearance agreement.
I'll take that as a yes. Things have broken down, at least in part. I'm not
Yeah, I would agree with that.
Mr. Delrahim, what can you tell us about that? Have they broken down, or are you still using it? Do you agree with Mr. Simmons' suggestion?
Well, the clearance process and the agreement is a process we are continuing to use.
But you'd acknowledge that it's broken down in at least some cases?
I would acknowledge that there's, over the last 20 years, and you might recall that Chairman Muris and Assistant Attorney General James, when they faced this back in 2002, I believe, entered into an arrangement that could have solved a lot of the problems, because this has been going on not recently, but in the past. The Senate Appropriations Committee put a provision in preventing the agencies from implementing that orderly agreement. But it was one of the two agencies that resolved, and it might have prevented some of these problems. But I cannot deny that there are instances where Chairman Simmons and my time is wasted on those types of squabbles.
Thank you for your candor on that point. As I mentioned in my opening statement, I don't think there is a sound basis. I don't think one can conceive of a sound basis for splitting up a monopolization investigation between your two agencies. Any monopolization investigation must look at the totality of the company's efforts in attaining or in maintaining monopoly power. That cannot be done piecemeal. It doesn't work. It's something that doesn't exist in the abstract and certainly isn't going to work in practice. Mr. Delrahim, have the Department of Justice and the FTC ever split a monopoly investigation between themselves before?
I'm not sure if there was.
You can't think of any?
I can't, and certainly not in the last 2 years that I discussed. But I want to clarify one thing. It's not so much the monopolization cases, because, I mean, frankly, most of the antitrust laws of Section 1 and 2 of the Sherman Act, maybe a Section 8 of the Clayton Act, and outside of merger, Section 7. But we would look at different conduct, perhaps, of the same companies, and that might be what we might be talking about here.
Okay, so you might have one agency more interested in one piece of conduct than the other, but by your own acknowledgement, both of these are monopolization-based investigations. Those cannot be done piecemeal. Mr. Chairman Simmons, the FTC and the Department of Justice are in fact structured differently. They have different policies, different procedures, in addition to having different personnel. In most cases, they're bound by the same substantive provisions of antitrust law, but the FTC also has some authority to act under a separate set of laws dealing with unfair methods of competition. Is it even feasible for your two agencies to split between yourselves what is, in effect, a single investigation when it comes to monopolization?
Well, It's not the normal thing to do, that's for sure, and we haven't done it in my recollection, and I've been practicing for about 35 years now. But it's also the case that we cooperate regularly with the state attorneys general on the same exact case, not even dividing
Applying
it up.
different standards of substantive law. I mean,
Usually, in many cases, they're applying the same standard. And sometimes it's helpful because they in particular have more expertise in local areas. So sometimes, particularly like, for example, on mergers involving gas stations, they know the terrain, they know what the local markets look like.
it is,
so
in
that's
fact, a
very
different
helpful.
sovereign, though. You're dealing with
It is a different sovereign. That's absolutely
You two
true.
are agencies.
And let me
within
just
the
say, I
same
mean,
zone.
ideally, you really do just want one agency from the federal government doing it, if for no other reason, because the resources that one of us is duplicating on the other could be applied to a completely different enforcement action
Right.
or investigation.
Right, and as you've both acknowledged, both of you could use and desperately need more resources. That being the case, it makes no sense to me that we should have duplication of effort when that has a tendency inevitably to undermine the effectiveness of what you're doing. Mr. Simmons, I appreciated your acknowledgement a moment ago about how this may be tripping things up. It inevitably does. Let's suppose hypothetically that you were asked for advice on setting up an antitrust regime within another country, within some foreign jurisdiction that didn't already have one. Would you, in any circumstance, recommend that they follow the U.S. model and that they have two separate agencies responsible for civil antitrust enforcement the same way we do here?
No, I wouldn't.
Mr. Delrahim, what's your answer to that same question?
It would be hard to imagine a system being designed at the first instance like we have today in multiple. Now, and as Chairman Simon says, not only do you have two federal agencies, you have, well, I guess I learned recently with the state AGs, 52 states who also enforce the antitrust laws. And all of them, based on a Supreme Court precedent, enforce the exact same federal law that we do, in addition to their state laws. So it's not the best model of efficiency.
Thank you. I see my time's expired. Senator Klobuchar.